Hi, everyone, and welcome. Hello, everyone. Welcome to live stream about disability law. My name is Sivan Tumarkin, and I'm co-founding partner, a lawyer at Samfiru Tumarkin LLP. We discuss long-term disability issues, and of course, in our firm, we also practice employment law, personal injury law, etc. But the topic today is long-term disability law. And I want to start off by talking about something that does come up quite often, and that has to do with CPP disability. Now, many people have questions about the interaction with regards to CPP disability and long-term disability. The insurance company may tell you you need to apply for CPP disability, and you may say, well, why do I need to apply for government disability pension if I have disability payments coming from you, or payments that ought to be coming from you? What happens if I don't comply and I don't apply? What happens if I apply and I get denied? How does that affect the denial, affect my benefits? So I want to talk about that and start with that. But of course, any questions you have about short-term or long-term disability benefits and issues with insurance companies, fire them my way, and I'll do my best to get to them through the session. So let's start off with the basics. What is CPP disability? Well, it's a federal government program that pays individuals who've contributed to the system a certain amount. I think the limits now are approximately $1,300 a month or so. Now, if you're receiving, let's say, long-term disability benefits, and the insurance company calls you up or emails you and says, look, we want you to apply for CPP disability, your first question is, well, why? Well, I'll explain why, and I'll explain what happens if you apply and what happens if you don't apply. So first of all, why are they asking you? Well, they're asking you because from their perspective, if you apply for CPP disability benefits from the government and you get approved, let's say you end up getting $1,000 a month from CPP disability. Well, you're not getting the long-term disability benefits plus the amount from CPP disability. You're not getting both. They're not stacked on top of each other. The LTD insurer, your disability insurer, gets a deduction. They get a credit for that. So if you're getting $2,000 a month from LTD, and then you apply and you qualify and you get $1,000 a month from CPP disability, you're not getting $3,000, unfortunately. You're getting still $2,000. The insurance company now has to pay you less. They have to pay you less by whatever amount CPP pays you. So then, of course, the question is, well, why should I apply then? Why should I do this? After all, you should be paying me, disability insurance company. Well, here's the reason why. There's a bunch of reasons, but here's the main reason. The insurance company will tell you that under the policy that you have with them, and I'm now talking generally, okay, every policy is distinct. Every policy of insurance we have to look at individually, but generally speaking, under most policies of insurance, disability insurance, there is a provision that states that if you are eligible and you receive CPP disability payments, the insurance company is entitled to that deduction. So the reason why they're asking you to apply is exactly that, because they want to get that deduction. They don't want to pay you more than they have to. And if the government can contribute, great. That's what they're trying to do. They're trying to then get a discount by having the government contribute to what it is that you're getting every month. What happens if you say no? Well, if you say no, I'll tell you what I've seen happen. In most cases, what happens is the insurance company says, well, you ought to be applying for CPP disability. Under your policy, you have an obligation. There's a provision that obligates you to do so. You've said you're not going to. Well, we're going to guesstimate what we believe you ought to be receiving by way of CPP disability. And then we're going to simply reduce that amount that we've guesstimated, irrespective that you haven't applied for it and haven't received it. We're going to guesstimate that amount. We're going to take that amount that we've guesstimated. We're going to now reduce the benefits we're paying you by that amount. So you're now in a situation where the insurance company is going to pay you less, but you're not receiving anything from CPP disability. So I've seen that. The other thing, which is more extreme that I've seen, it's very rare, but it did happen a few times, is that the insurance company says, well, you have an obligation under your insurance policy to apply for CPP disability. We've told you to apply. You haven't applied. You're now in breach of your obligations under the disability policy. Therefore, we are going to stop paying you altogether because you've breached the policy. You've breached the contracts that we have between you and us. That's more rare. Now, what are the benefits of applying for CPP disability? I tell people, look, if you can apply for CPP disability, you should, especially if you're on LTD. Why? Number one, if you get approved, it means that the government has now recognized that you have a disability that is severe and prolonged. These are two criteria which are required to be satisfied to get CPP disability. Arguably, that's a harder test to meet than the test for long-term disability with your insurance company. So the reason why this is important is because in many instances, when the insurance company cuts off people off of disability, they say, well, you're not disabled. You're not disabled. You can go and work. Well, if you apply for CPP disability and the government says, yes, we believe you're disabled, it's going to be that much more difficult for the insurance company down the road to cut you off, to end your benefits, because they're saying you're not disabled or not disabled enough. So that's number one. Number two, if they do cut you off at some point in the future, the insurance company, and we have to fight them on your behalf, well, guess what? You have another income source. You have CPP disability that's now paying you monthly. So these are two primary benefits. There's other benefits as well, but these are the two main ones. So I always tell people, make sure that you apply for CPP disability, and we actually have people on the team that can help you with that if you need help with that. Now, I want to get to another question, which is very important. What happens if you've been denied your claim? Okay, so we're going to move away from CPP disability for a moment. You've been denied your claim, or you've been cut off disability. And the insurance company sends you a letter or an email. They're explaining why it is they denied your claim or why they cut you off. And now they're saying, but you have the option to appeal. Should you appeal that decision? What does the appeal mean? What is this appeal? And what do we make of it? Well, this is really important to understand. These appeals are internal processes. These are internal processes by the insurance company. So if you are appealing, you're asking them again to reconsider their decision. You have to understand this is not done by a third party, by a judge, someone else. You are re-asking the same people who cut you off initially or denied your claim to reconsider their decision. Anecdotally, I can tell you that in the vast majority of cases I have seen and my colleagues have seen, those appeals get denied. That's really, really important to understand. And it's important to understand because they'll deny your appeal, then they'll invite you to appeal again, you'll appeal again, and they just run out the clock because there's a 2-year limitation period for starting legal claims to take legal steps to force the insurance company to pay you your benefits. And if they can keep you on that kind of hamster wheel, appealing and appealing and appealing, denying, guess what? You have no money, you are potentially out of time, the stress increases, the anxiety increases, the bills increase. So I tell people, look, before you even consider appealing, contact us, contact me, my team. We'll tell you what your options are. If you still want to appeal, go ahead. We'll even tell you how to strengthen that appeal potentially. But again, remember, you are appealing, you are re-asking the same people who denied you in the first place or cut you off to reconsider their decision. I want to get to some questions that we have right now. One came from Mara. I'm going to attempt to return to work over the next few months at my request, but my doctor is concerned. If I'm not able to successfully go back, can I go back on LTD? Excellent question, Mara. There are several things I want to say about this. This is common. And by the way, kudos to Mara, kudos to anybody who's trying to get back on the horse, right? The idea of long-term disability is not so you have payments for life unless you need them, but to help you, to give you time to recover, to get treatment so that you can get better and get back to work. When you try to return back to work, under most long-term disability policies, and Mara, I would want to see your policy, or you can take a look at yours, search for a provision. It's often referred to as a recurrence provision, recurrence clause. And what it says is that if you try to go back to work and within a certain period of time you're unable to continue, then you can go back on LTD. In other words, the payments snap back, okay? Of course, that's with your doctor's approval and doctor saying that you cannot work, etc. The problem, this is in theory. The problem is in many cases, insurance companies will put up stumbling blocks and will put up some resistance. Not always. Sometimes they will put you back on LTD. But the point is you need to understand that your policy will have a provision or a section that deals with this issue of what happens if you try to go back to work and what happens if you fail. There is going to be a time frame that you have within which you can go back on LTD if you need to. If you don't apply or reapply for LTD within that time frame, if you have difficulty working, then you may have to restart the whole LTD process from the beginning, which means that there is a period of time where you don't get paid. And I tell people, listen, if you're dealing with the situation and the insurance company is giving you a hard time, then contact me. It'll cost you nothing for us to chat, for me to look through the documents and talk to you about your case. Now, I do want to mention something about what Mara said. She says, my doctor is concerned. Presumably, Mara wants to go back to work, but her doctor is concerned that maybe she's not ready. I think that's what she means. Here's what I tell people. Number one, you need to be, as much as possible, in tune with your doctor or doctors. You want to make sure that you follow doctor's advice. Assuming you do, your doctor needs to provide a note. This is the most ideal situation, a note that you can give the insurance company where the doctor essentially says that he or she feels that you are ready to try to go back to work. Notice the word try. Very important. Very important. If your doctor says Mara is ready to go back to work, and then Mara tries to go back to work, has difficulties, and needs to go back on LTD, the insurance company is going to look back at the note from the doctor and say, but the doctor said she's ready to go back to work. Secondary scenario. Doctor says Mara is ready to try to return to work. We will reevaluate down the road if, in fact, she's ready. Now there is a door that's been opened, left ajar. In the event that Mara is unable or is unsuccessful at that attempt to work, well, guess what? The doctor can now write a note saying, well, we tried, she did her best, but I think that she should still be on disability. She still needs treatments. So again, remember, anything you give from the insurance company, from the doctor to the insurance company, it should be very explicit that this is an attempt to go back to work, that the doctor is not saying, unless the doctor truly believes it, that the person is 100% ready to go back to work. I know that I'm splitting hairs here, but trust me, the insurance company will latch onto anything, any word, any comma, any period in any letter that they see to try and make the argument that you should be ready to go back to work and they shouldn't pay you. Let's go back to another questions from Reddit. I recently had a serious slip and fall injury at a local grocery store. I injured my back and I'm in a lot of pain. I likely won't be able to work for a while. How would this be translated to LTD coverage? What should I do to deal with the injury portion? And is there any overlap with an LTD claim? So excellent question. Yes, remember that to be on long-term disability, the criteria is that you cannot perform the tasks of your employment. It doesn't say what is the reason for that. There are some insurance policies out there that are specifically accident insurance companies, but typically no. Typically, LTD insurance is paid if you cannot work. Well, you may not be able to work because of an accident or because of an illness or because of anything, a combination of those issues. So in this case here, this person here had a slip and fall. We deal with slip and falls all the time. I can tell you that in many instances, we are able to recover significant compensation for our clients. So I would urge you to contact us after the live stream. We can talk about your specific situation. But with respect to your injury here, assuming that your injury is prolonged, assuming that you do need long-term disability and you have that coverage either through your health benefits at work, or many people don't have coverage at work, you can purchase that privately. Of course, before the incident, not after. But if before the incident you had coverage for LTD, either if you purchased it privately or if you had it as part of your health benefits package at work, you should be able to apply for long-term disability as long as you cannot perform the essential tasks of your own occupation. You'll need your doctor's backing here, the doctor to say that you need time off work, you need time for treatments. The doctor may be asked the diagnosis, the prognosis, and a whole bunch of other questions, essentially so the insurance company can understand what are your limitations, what are the functions you cannot perform, etc. But there is an overlap as between long-term disability and personal injury because they're different aspects. I want to digress for 1 second. Sometimes it happens that people have an accident, let's say a car accident, and in a car accident, especially in Ontario, but in other provinces too, and we do work in other provinces, in BC, in Alberta, Saskatchewan, we do work throughout Canada. Sometimes you have different insurance companies and different entities that we have to deal with, whether it's a car accident, slip and fall, an illness, whatever it is. The LTD insurer, sometimes the employer will give you problems because you can't work. Very, very important to understand that you have to understand how to navigate these issues. Now, you as an individual who doesn't deal with this day to day, I don't expect you to understand it. What I want you to know, though, is that if you are seeking legal advice, and this is key, you need to go to a firm or lawyers or a lawyer that has expertise or at least knowledge in these areas, in injury law, in LTD law, maybe in employment law if you have that, because they do intersect. If you get money from one side, it may be owed to the other side. So very, very important to understand. So certainly we do injury law, we do employment law, and we do disability law. And so we understand how all these things intersect, and we have lawyers that actually have a focus, specialty on all these areas. Let's move on. Question on Reddit. I recently had a, oh, that's the same accident here. 1 second. Okay, there we go. I think I have Lyme's disease. My doctor is going to start testing. It's been heavily impacting my daily life. Going off work has been a discussion I've had with my doctor, but does LTD cover this? Okay. Yes, the question is, and I get this often, by the way, that, is this condition covered by LTD or is this injury covered? Here's the general answer here. Long-term disability coverage, again, this is general comment. You may have a policy that is specific to only injuries, but generally, long-term disability, especially when you have it through a group benefits coverage at work, long-term disability will kick in or should kick in, should be triggered, so you get benefits if you cannot perform the essential tasks of your job, of your occupation. That's it. There is no analysis as to whether that's because of an injury or if it's because of an illness or because of anything. The question is, can you not work? So if from because of a Lyme's disease or any other type of disease, you're unable to work, you have certain conditions, you have limitations on your functionality, then yes, the LTD insurer should cover that. If for whatever reason, you get a denial from the insurance company, reach out to me immediately. Again, it doesn't cost anything to get this information. I tell people this. You have nothing to lose. This is what we do. What I do, what my team does across the country, we advise people about whether or not their denials by insurance companies are correct or not. And I can tell you that in a large segment of those cases of people who contact me, again, anecdotally, they have a case. Whether people want to pursue those cases, different story. But this is my job to tell you if you have a case. The insurance companies are there for one purpose and one purpose only. That's not to help you, unfortunately. That's to make money. And the way they make money is by taking in premiums, raking in premiums, and paying as little as possible, perhaps even nothing. And I've seen cases, people came to me with a denial letter with over 10 reasons. I call them excuses, but let's call them reasons for why they're not going to pay the claim, why they've denied the individual. And the person says to me, but I'm disabled. And we've resolved these kinds of claims with the insurance company paying money, oftentimes in the hundreds of thousands of dollars. So do not take what the insurance company says at face value without checking it first. That's the lesson here. Okay, from Alex. If a worker is granted LTD for a chronic mental stress injury, what are the benefits, drawbacks if the same claim is accepted by WSIB, that's workers' compensation, and the worker received loss of earnings benefits? Okay. So oftentimes those two benefits, it's one or the other. And oftentimes if you get WSIB, then you're not going to get LTD, or vice versa. The problem with WSIB, the problem with workers' compensation, I don't practice workers' compensation. There's people that I know that I refer clients to if there's an issue on workers' compensation. The problem is that workers' compensation is very difficult to deal with. It's a government or quasi-government program. There have been many articles in the Toronto Star and other publications about some of the hell that people go through. So my advice is, think twice before applying to WSIB if you can go through LTD. Sometimes there's no option. Sometimes it is a workplace injury and you have to go through WSIB. But if that happens, it may affect your LTD claim. You may not have an LTD claim, or you may have a claim, but because LTD is entitled to a deduction for whatever you get from WSIB, let's say those loss of earning benefits, you may not have anything owed to you by the LTD insurer. So, keep that in mind. Chronic mental stress injury, anything to do with mental stress, psychological issues, psychological injuries, illnesses, those are, in my experience, significant claims. Those are claims that, from the LTD standpoint, despite the fact that insurance companies don't want to admit that, I can tell you those are claims that oftentimes individuals get significant amount of compensation for. And if you think about it, if you have an orthopedic injury, let's say you broke your ankle or even your back, God forbid, you may not be unable to carry out some of your work duties. But if you're depressed and suffer from significant depression, anxiety, etc., you may be paralyzed, essentially. You may be in bed all day. So psychological injuries, psychological diseases, psychological illnesses, those are very significant. If they were caused through your work, you may or may not be qualified to seek LTD. Let me get into this. Sometimes when people apply for long-term disability benefits, and it's because of some kind of a mental issue, a psychological issue that developed because, let's say, of a workplace environment, a toxic work environment. The insurance company, the LTD insurer, may say, well, this is a work issue, so therefore it's not an LTD claim, it's an employment claim. You have to go to an employment lawyer to deal with a constructive dismissal situation, or at most, it's a WSIB claim. This may be true if you are in a situation where if you were to be placed in a different work environment, suddenly you can work. In other words, if the toxicity of the workplace, if the issues you're having is specifically situated at your workplace, in other words, if you were working somewhere else, you'd be fine. Maybe there's an argument there that you don't have an LTD claim. Okay, that's a situational type of a situation of a claim. In that case, I would want you to be speaking with one of my employment lawyers, and they'll advise you what to do with the employer here. However, if you have a situation where it may have arisen during your workplace, there was a toxic work environment, there were issues, but now the situation for you has become generalized. It doesn't matter where you go to work. You're now depressed, you're now anxious. In other words, they took you from the toxic place, they put you in a healthy place, but you still can't function. Now your condition is considered to be generalized. In that situation, you have a claim against your LTD insurer. And at that point, we can go after the LTD insurer and we can hit them hard if they in fact deny your claim. Again, every case is different. I want to stress that every situation is distinct. I'm trying to kind of cover as many scenarios as possible here. Okay. Oh, Manuel writes, it happened while I was out hiking, so it's not work related, but I have an insurance plan through work. Okay, I understand. This is in reference to the LTD and WSIB. If your injury did not happen during work, it's not a toxic work environment issue, WSIB will not cover this. But if you have long-term disability coverage through work, which is what you're saying, and you can't work and you need time off and you're getting treatments, whether it's a psychologist, psychiatrist, psychotherapist, your family doctor, you should be able to apply for long-term disability and you should be able to get it. And if you get a denial for any reason, you reach out to me immediately and we will help. Okay? Question from Maria. I'm a member of the teachers union. Do I have to deal with my union first to handle any disability claim issues, or can I speak to a lawyer directly? Fantastic question. So I don't know how many of you here attend some of the employment law live streams that we have. But on the employment side of things, if there's an employment issue, not disability, employment issue, you have to go to your union for representation. You cannot have an external lawyer kind of fight the employment claim. This is the law here. But on the disability front, that's not necessarily the case. In many cases, we are and will be representing individuals who are unionized, like teachers, who are suffering from an LTD related claim, who've been denied by their LTD insurer, who have been cut off benefits by their LTD insurer. You do not have to go to your union first. At the very least, I would urge you to contact us first so we can discuss it and tell you if you have to go through your union or not. I can tell you we represent many teachers, some of which have made the news, actually. But no, typically, if you're a teacher here in Ontario, you do not need to go to the union. There is not to speak badly in any way about unions or union lawyers, but their focus is employment law. Their focus is the collective agreement. Their focus is the relationship between the individual and the employer. Their focus is not disability law. Their focus and knowledge is not based on the relationship between the individual, the teacher, and the insurance company that insures teachers for disability. And I always like to say, look, where would you go for advice if you need a mechanic? You go to a mechanic. Where would you go if you need a heart doctor? You go to a heart doctor, not a dentist. The same thing with us. We deal with disability law. Your union deals with the collective agreement and employment issues. So if you have a choice, if I had a choice, my choice would be to go to the lawyers and law firm that specialize, that have a focus on disability law. I hope that answers your question, Maria. But yeah, we've helped many teachers in the past. I mean, talk about a tough job. Question from Hamish. What if you're dealing with complex PTSD, post-traumatic stress disorder, and have developed anxiety and depression conditions from childhood events? Would this be something they could argue you don't have a claim for? I am assuming, Hamish, that you are referring to pre-existing conditions. that because there are childhood issues here, that those are from before. They may argue that, but so what? Let them argue that. Here's something to consider, and this would be the counter argument. Let's say you experience those childhood issues, the trauma that happened back then. Um, you've been able somehow to deal with those issues to the point where you were able to work. I'm assuming you were working. So if you were working and you had health benefits, and at some point something happened in your life, maybe it was COVID, maybe it was a traumatic event, maybe who knows what happened, something happened now that triggered complex PTSD, something that relates back to your experiences in your childhood, that's a new event. In other words, they can't argue pre-existing condition because you were able to deal with those issues from your childhood. Something happened now, whatever that may be, that now triggered your situation here. So this is really, really important here, really, really important to understand that insurance companies will often argue pre-existing conditions as a defense, but that doesn't always hold water. Many times we can go around it. Again, remember, insurance companies, they'll throw everything at the wall. And listen, I used to work for insurance companies almost 2 decades ago. I did the same thing when I worked for them. I don't begrudge them. I don't like the system. I don't like that they're picking on disabled people. But you have to understand that when they tell you something, when they deny your claim, when they're giving you a reason or an excuse for why they'll do this or that, that does not necessarily mean that they are legally correct. And in fact, in many cases, they are not. But you won't know unless you seek that legal advice. And we'll tell you if we think you have a case or not. If there's no case, I'm going to tell you there's no case. If there is a case, I'll tell you there is a case, and here are your options. Here's what you can do about it. And then you decide. You decide how to proceed. Question on Facebook from Fina. If I'm receiving a pension or have unsecured debt, is this something an insurance company would look at as income? Okay. Let's deal with the pension issue. If you're receiving a pension, it may or may not be deductible from an LTD benefits amount that is payable to you. It depends on the wording of the policy. In many instances, some of these LTD policies contain provisions that say that if you get severance, we're entitled to a credit for those. If you get WSIB, we're entitled to a credit. If you get CPP disability, same thing. And sometimes they'll say it about pensions as well. But here's the thing, and this is a nuance here. I won't delve into it. I'm not going to go into a rabbit hole, but I want you to understand. When we look at the contract between you and the insurance company, that contract is the insurance policy under which you're owed benefits. If there is something there that says that they're entitled to something, and we look at that, and we can interpret that provision with our skills in a way that is reasonable, I stress reasonable, and favorable to you, and the insurance company comes and says, well, no, our interpretation is that it's favorable to the insurance company. When you have two competing reasonable interpretations when it comes to an insurance contract, the law in Canada, generally speaking, is that a court will side with the individual. It's called the doctrine of contra preferentum. It's a Latin term. Essentially means that if there are two or more reasonable interpretations to a particular provision in a contract, it will be interpreted against whoever drafted the contract. And in this case, it would be the insurance company. So even if you have a pension here, and the insurance company tries to get their hands on it, we're going to look at the provision in the policy under which they are trying to get that money, and we'll see if we can interpret that provision differently in a way that's favorable to you, and then at least we have an argument to get the insurance company not, in fact, to get the money from you. You mentioned unsecured debt. I'm not sure exactly what you're referring to, but if you have a debt, that doesn't impact your LTD unless you're bankrupt, in which case there's other considerations. But if you have debts, no. Really, insurance contracts, when they have provisions that favor the insurance company, it's really in relation to income that you're receiving or some kind of money you're receiving. Oftentimes, insurance companies, again, try to latch on to whatever they can to decrease the amount of money that they have to pay you. That's, again, where we come in, and you can ask us questions. Again, it doesn't cost anything to talk to me or a member of my team about any of this. Great. Somebody says here, this is such a great resource. Thanks so much for the information. You're very welcome. Quick point. If your union provides coverage for WSIB claim, you should contact them before contacting a lawyer. There may be a disability specialist in your union who will rep for you free. Good luck if you have that. If you have somebody there in the union, I can tell you that in my experience, you don't have, I've never seen specialists or lawyers that union companies have on staff that are going to have expertise in disability law. But I have no problem people checking with your unions. Listen, we're busy. We're doing this to educate the public. So if Alex is correct here, and there is a union out there that has these specialists, unions typically don't like to spend money, just like insurance companies. So typically, when they have lawyers that they go to, their specialty is employment law and the collective agreement, not disability type work. But you know, to each their own. Just a question: is it normal to change VRC every 2 months? VRC, I'm not sure what you mean by VRC. Maybe just clarify that for me. That's all the time that we have today. Anybody has any questions, please contact me directly. Contact any member of our team. Again, remember, it doesn't cost anything to talk to us. It doesn't cost anything to get this information. Go to our website. I want to mention that we have a live stream employment and disability law this Thursday, tomorrow, June 26th at 12:30 p.m. Eastern Time with Alex Lucifero. He's a partner in our Ottawa office. Again, tomorrow, 12:30 p.m. EST. The next disability law Q&A is going to be July 8th at 10 a.m. Pacific time with Martin Williams out of BC, our managing partner in BC, probably the top disability lawyer in British Columbia. Again, that's July 8th at 10 a.m. Pacific time. Thank you very much. Really appreciate it, your attention here, and look forward to speaking with any of you and seeing you next time.